Hello and good evening to everyone. Welcome to today's session. I hope you all are safe during this pandemic. I am Nishi Jain, currently pursuing my fifth year of law school, and I am an intern at JLG Law Offices. I once again welcome you all to today's webinar on the topic Increase in Cybercrime After the Outbreak of COVID-19. Hope you all have an engaging and an insightful session today. Thank you for taking out your time and being here with us. I would further like to invite my co-moderator, Ms. Harshvi, to proceed with the housekeeping rules. Thank you, Ms. Harshvi. Over to you.
Thank you, Ms. Nishi. Good afternoon, everyone. I'm Harshvi Chaumal, a fourth-year law student from Amity University, Rajasthan. Before I introduce to our four panelists, I would be telling few housekeeping rules. Participants, including panelists, are requested to keep their mics on mute. If any person has anything to communicate either to the co-moderators or the panelists, are requested to mention there in the chat box. We'll be having a Q&A session wherein all the attendees are requested to mention their questions in the chat box. Our panelists would be happy to help you and resolve your query. Today's panelists are Ms. Anushka Bhatia from IP University, Mr. Titash Bhattacharya from Christ University, Mr. Rohan Jain from IP University, and Ms. Michelle Modi from Amity University, Rajasthan. Now, I would ask my co-moderator, Ms. Nishi Jain, to proceed further.
Thank you, Harshvi. Now, I request all the viewers and panelists to have a look at their screens and monitors. A small video clip is going to be played. I request the moderator to play the video.
Access granted. Access granted.
We are Dark Web. You will not stop us. This is just the beginning.
Thank you so much. As after looking at the video, you all must be having an idea as to what today's session is going to be all about. Cybercrime is the biggest challenge these days with advancement of technology and access to it across the globe. So hence in today's session, we are going to look into the following agendas. The first one being jurisprudence of cyber law. The second one, understanding cybercrime concepts with real-life examples, including incidents after the outbreak of COVID-19 and its associated cyber law challenges. The third one, whether the IT Act and the landmark judgments are sufficient enough to tackle these issues. And the fourth one being, how can a person keep himself safe in cyberspace during and after COVID-19? Now, I would like my co-moderator, Mr. Roy, to give an introduction of what is cybercrime and its essentials. Over to you, Mr. Roy.
Right. Am I audible?
Yes, Mr. Roy, you are.
Yes. Firstly, thank you so very much, everyone, for taking out your times and attending this webinar. The issue which we are discussing today is cybercrimes during the COVID pandemic. Now, one thing we need to understand is that with the onset of this surprising element into all our lives, that is the COVID-19 issue, many people are engaging into different activities throughout their days. Some are cooking, some are learning how to drive, some are trying their hands at drawing. But one thing is common between all of us. We are constantly engaging with the internet. And because of our constant engaging, the spike at the rate at which people are engaging with the internet, the number of cybercrimes are increasing day by day. The fiasco regarding the cybercrimes has been there since the inception of the World Wide Web, that is the internet, what we deal with today. But the surprising element is that at the very beginning, there wasn't such a fiasco regarding the cyber crimes and at the rates at which they were happening. Earlier, they used to happen with multimillionaire conglomerates, tycoons, then big banks, and other famous personalities. It never affected really the common man of the country, or for that matter, anywhere on this planet. But as more and more people are engaging with the internet, the common person who's maybe who earns a meager salary of around 10,000 rupees a month is also falling prey to a cyber crime which is happening maybe next into the next computer what we have. Therefore, what we need to understand is that the people who are actually becoming a part of this cyber crime, whom we call as cyber criminals. I'll request the participants to please mute their mics. Thank you. So as I was saying, that the cyber criminals who are actually engaging into all these activities, that is money laundering, credit card frauds, everything, what's the common element is that they all are feeding on our anger, our desperation, our partial depression, which we do not want to accept, but yes, we all are in. Because staying for 60 or 70 odd days at home, staring at one picture, not being able to go out, becomes something that we all get anxious about. So they take advantage of these elements, these psychological emotions of ours, and they play with it. Well, to name a few examples of recent cyber crimes that has been happening, especially within the jurisdiction of India. The first one is essentially the most important one, that is the fraud regarding the PM Cares Fund. So as we all know, the central government came up with this very novel idea of a PM Cares Fund, wherein a central government treasury was formulated, wherein the common man, or for that matter, any person on this planet Earth could contribute to the Prime Minister's fund, which would be used for fighting the war against the COVID pandemic. But what we started observing was that these cyber criminals started taking alternate approaches. What they did was, so the name PM Cares Fund, they started manipulating it. Somebody started using the name PM Fund. Somebody started using the name PM Cares Fund. Now the S, they use 2S. Somebody started writing PM Fund. So all these different names started diverting the money which was actually meant for the PM Cares Fund, the original one kept by the central government. Now these notorious people started sending these WhatsApp that kindly contribute to the PM Care Fund or the PM Fund. That will help our fight against the COVID-19. But what the innocent people started doing was they slipped into the mischievous attitudes of these people, and they started sending in the money with the simple hope of fighting the COVID-19 as a countryman. But what eventually happened was that these people started falling prey to cyber crimes. Now, once a person, for example, paid 500 rupees towards a contribution, now that person in 48 hours saw that his entire bank account was empty. Why? Because the person sent in the money to the wrong account, and that wrong account, and the person was operating the wrong account, took away all the money that came from that account. The second example is the selling of drugs and medicines in the name of the COVID-19. Now, as for this particular aspect, I would like to jump to the continent of Africa, wherein, according to the World Bank, there are more than 40% of the developing countries of the world. Now, what is happening is that since they have a little or a relatively less access to internet, whenever they see or come across any ad, or for that matter, any pop-up that tells them, we have the medicine for COVID-19, you don't need to worry. Kindly order on this website and contact this number and send in the money to this account. The innocent people thinking that yes, the world has actually come out with something called the vaccine for the virus, for which the entire world, the first world countries are coming together to formulate, but are still not being able to. Unfortunately, they are buying these random medicines. Some people are dying, and the others are seeing their money being swiped out of their bank accounts. The last thing, that is the risk of the school-going students. What is happening is that the education has taken a drastic drift. The college and the school-going kids have now shifted their classrooms to their homes. But what is happening at the same time is that using different unsecured platforms has led to the exposure of these children to certain acts which are punishable under the Indian Penal Code, that is nudity, sexually exploitative content, which the hackers tend to penetrate into these software accounts that we are using as of now. So with this, I've set the premise for the discussion today, wherein the panelists will be discussing each and every aspect of this. And I hope that the panelists will be able to give out an answer, both legally and logically, that how to counter this cyber terrorism, this cyber crimes that are happening during the COVID-19 times. With this, I would like to pass on the mic to Nishi. Nishi, please continue. Nishi?
So, thank you, Mr. Roy, for your introduction. Moving on, I would like to invite Ms. Harshvi to proceed with Agenda 1 of today's session.
Thank you, Ms. Nishi. So now, I'll be beginning with the Agenda 1, that is jurisprudence of cyber law. According to me, cyber jurisprudence, like any other jural science, is the study of laws relating to cyber. While technology conquers the world at an unimaginable speed, the issues concerning its regulatory aspects are also on the looming concerns for all the jurists over the world. Cyber technology is a double-edged weapon, a menace in the wrong hands, and unless regulated, can be as harmful as a nuclear weapon. So with this, I would like to ask Ms. Anushka, would you like to share your views on cyber jurisprudence and also tell us whether there is a conflict between IPC and IT Act?
Well, thank you for asking my opinion, Ms. Harshvi. Coming to cyber jurisprudence, in a very layman language, cyber jurisprudence is the law that relates to cyber crime. Cyber jurisprudence also deals with the principles of legal issue that regulates our cyberspace and our internet. Now, coming to the question whether conventional laws are adequate to cover cyberspace or not, let us consider a situation where a crime is committed by spread of pornographic material or some criminal threats by emails or a person defaming other person on a website. In all these offenses, computer is mere incidental to the crime. A person distributing pamphlets and promoting racial enmity, or a person doing such on a website. Both are of similar essence. Where technology is being used to commit such crimes, government can simply impose strict liability by imprisonment or with fine. Coming to spread of pornographic material, it could be penalized under Section 292 and Section 293 of our Indian Penal Code. As long as we are dealing with these situations, conventional laws are adequate. The challenges arise when we deal with more complex issues such as theft of data. Considering an unauthorized person who just simply copies the data from my computer onto his pen drive, would it be considered as a theft? Under conventional law, theft relates to when a person illogically and illegally moves the possession of a data from a possession of someone. Presuming here that the intangible data is our movable property, still theft has not occurred because the original data is still under my control, under my possession. But thief has merely copies the data from my computer networks. So, under conventional law, theft has not occurred. Giving another example of Section 43H of Information Technology Act, where a person is penalized when he charges the services of his account from the account of another person by tampering or by manipulating computer networks or computer systems. When a person tampers the computer of his electricity supplier and let his neighbor pay for his electricity consumption, would be penalized under Section 43H of our IT Act. Of the similar essence, there is no provision in our conventional law, mainly under our IPC. Now the question arises that what will happen when there is a conflict between our conventional law and our cyber law. So I would like to give an example by quoting the most famous Sharad Babu case, also known as Bazi case. Now in this case, there was a conflict between the provisions of our Indian Penal Code and our Information Technology Act. What happened in this case was, there was an obscene video which was posted online on Bazi.com under the category books and magazine and subcategory ebooks to avoid detection purposes. So there was a conflict between Section 292 of IPC and Section 67 of the IT Act regarding electronic records. Hence, the Supreme Court was of the opinion that whenever an offense involves electronic record, the IT Act would prevail over other general laws because it is a special act and the intention of the legislature behind this act was also same, giving another principle of interpretation that special laws would prevail over general laws and latter laws would prevail over prior legislations. IT Act would prevail, and further adding Section 81. So in my opinion, whenever there is a conflict between the two, the IT Act would prevail. That's all. Thank you.
Thank you, Ms. Anushka. Now, I would ask Ms. Modi if she wants to add something to it.
Yes, Ms. Harshvi. I would like to add one thing, that another legal challenge emerges as violation of privacy. Section 66E of the IT Act prescribes punishment for violation of privacy. and provides that any person who intentionally or knowingly captures, publishes, or transmits the image of a private area of any person without his or her consent under circumstances violating the privacy of that person shall be punished. But there is no provision in the IPC that mirrors Section 66E of the IT Act, though Section 292 and 509 of the IPC do cover this offense partially. Cyber terrorism. Section 66F of the IT Act prescribes punishment for cyber terrorism. There is no provision in the IPC that mirrors Section 66F of the IT Act, though Section 121 of the IPC does cover this offense partially. Also, the trial under IPC and IT Act could not be done, as in the case of Gagan Harsh Sharma versus the state of Maharashtra. Offences petitioners were charged under Section 408 and 420 of the IPC are non-bailable and cannot be compounded other than with the permission of the court. Offences under Section 43, 65 and 66 of the IT Act are bailable and compoundable. The High Court of Bombay, referring to Sharad Babu case, held that the petitioners could only be charged under the IT Act and not under the IPC for offences arising out of the same actions. Thank you.
Thank you, Ms. Modi. Now, I would ask my co-moderator to proceed with the next agenda.
Thank you, Harshvi. Moving on to the second agenda of today's webinar, which is understanding cybercrime concepts with real-life examples, including incidents after the outbreak of COVID-19 and its associated cyber law challenges. What if I say that the app you use daily for a webinar or presentation is hijacking all your personal data? Or maybe you're the next person to lose money from a bank account, or you're being continuously monitored by the dark web. Scary and confusing, right? This is the present scenario where a lot of cybercrime has been increasing day by day. So COVID-19 pandemic has made the society a lot vulnerable in lots of aspects. So having all these questions in mind, I would like to invite Mr. Rohan. Mr. Rohan, in your opinion, do you think what kind of cyber crimes have increased during this period, and what legal challenges can be faced if you look at it from the Indian perspective? Over to you, Mr. Rohan.
Thank you, Ms. Nishi, for asking my opinion on this. I would like to state, as we all are under lockdown period, and we have very soon realized that we are totally dependent upon the internet, starting from education on online platforms like Google Meet, or while purchasing goods on e-commerce platforms like Amazon India, Snapdeal, or Flipkart. And undoubtedly, our interaction is totally on the social media platforms like Snapchat, Telegram, WhatsApp, Facebook, and there are many other apps. On the other hand, we are also watching and reading news on our televisions and newspaper, where after every 2 or 3 days, we are seeing that there are numerous of attacks, whether it be an attack on the WHO official credentials, or we have found vulnerabilities in the Arogya Setu app and as well as Beam app. And there are also taking benefits that they know organizations are working from home, so they are not accessible to their computer system. Cyber attackers are taking advantage of this. You know what type of techniques they are using nowadays? They are using two types of techniques. One is phishing and the other is rat. I believe everyone knows about phishing, but rat is remote access trojan. Let me give you an example. Suppose there are two persons, a person X and a person Y. A Mr. X is a hacker and Mr. Y is a victim. Mr. X creates a video file and inserts a trojan in that, trojan virus, and send it to a Mr. Y by claiming and writing in that with the video that please download and open this video to see which person is tested corona positive in your neighborhood area. Being very eager, he downloads and watches that video. The moment he had downloaded that video, he have given total access of his phone to the Mr. X. By total access, I mean his files, including PDF file, doc file, and zip files, and even front camera, rear camera, and contacts, and he can even make calls also without even getting noticed. And there may be instances also you have seen during this lockdown period that there was a case which is very popular, but that there were no apps which were developed and uploaded on the Google Play Store. And when the apps were uploaded on Google Play Store, it was written in their description that these apps will tell you the number of corona positive patients in your neighborhood. The very brief facts of both the cases are, in boys' locker room case, there were few boys which have created and signed up on the Instagram platform, and by signing to the terms and conditions which they provide while signing up, After signing up, they have used the platform and created a group where they have shared obscene and mock pictures. And somehow, matter got to the knowledge of authorities, and a case was filed against them under section 67 and 67A of the IT Act, which deals with, these sections deal with transmitting, disseminating, or sharing the obscene content online. With by online, I mean by the help of application. And there was an app among many apps named as Corona Live 1.1. What is interesting in this app was when you download and install that app, it won't ask even a single permission. The moment you have downloaded, you have given total access to the app. So what is common and what is to be noted in both the cases? And you all might be thinking this also, that whether committing such crimes or unlawful acts was even possible if there is an absence of Instagram as well as Google Play Store. Whether it is possible, can they be held liable? Yes, my answer would be yes, they can be surely held liable for this. That you have to not abet or aid or conspire that unlawful act, and as well as you have to perform the due diligence. And apart from this, you have to perform the which you have received on your platform and have to follow and comply with the intermediary guidelines of 2011. But these guidelines states, you have to
Rohan,
provide them.
your voice is breaking. Just take care of the mic a little. Thank you.
Okay. Am I audible now?
Yes, now you're audible. Please go.
What is stated in these intermediary guidelines of 2011 that you have to provide user agreement and rules and regulations before giving them access to your platform. So I would request the moderator, Ms. Pandita, to please share the screen so that we can have a look on the various intermediaries that include these clauses or not. Ms. Swarnika Tyagi, please share the screen. Please click on Instagram. Here you can see it is specifically written, you can't do anything unlawful, misleading or fraudulent or for any illegal or unauthorized purpose. Secondly, you can't violate these terms or our policies, including in particular the Instagram community guidelines, Instagram policy and music guidelines. Further, you can't do anything to interfere with or impair the intended operation of the service. Please move on to Google Play terms. Here also you can see content may be offered by Google or made available by the third parties not affiliated with the Google. Google is not responsible for and does not endorse any content made available through Google Play that originates from a source other than Google. And please move on to Amazon India. Here also you can see it is written specifically, Amazon is only a facilitator and is not and cannot be a party to or control in any manner any transaction on the website. What is noted by all these three is that they have tried to take the benefit of section 79 by following the guidelines of 2011. And further, what is written in these guidelines is also that they have to also appoint the grievance officer who will acknowledge their complaint within a period of 36 hours, and then they have to redress that as per applicable laws of India within a month, and then they have to disable that content as per applicable laws without mediating the evidence, and they have to preserve that evidence for investigation purpose for at least 90 days. So this has created a burden because there is a huge increase in the internet usage of the users during this COVID period, and this increase is more than ever before, and they have to acknowledge each and every complaint. But you might be wondering that is it possible if there are so many users, there are millions of users that are using this platform, if few lakhs people is it possible for them to revert back to each and every complaint? Fortunately, this position was clear in the case of Chair Singhal versus Union of India, where our apex court had stated that the word actual knowledge written in section 79(3) of the IT Act has to be in the meaning that it has to be order of court. When we talk
Rohan,
about Article 19(2).
I'm so sorry to interrupt, Rohan, but your mic is again disturbing and we are getting queries for the same because people are missing out on points. So if you could just start with the case law, which you started discussing as of now, the Union of India case,
okay.
And just make sure your mic is a little stable.
Am I audible now?
Yes, you're audible. Just make sure your mic is a little stable. That's it.
Okay.
It's going great. Just continue.
Okay. Thank you. In the case of Shreya Singhal versus Union of India, it was held that the actual knowledge written in section 79(3), it has to be read down in the meaning that there has to be an order of court. Then only court will consider that the intermediary has the actual knowledge and they have to acknowledge and redress the complaints as per the intermediary guidelines of 2011. And this is my view on this, that this is the biggest challenge as the number of users and the internet usage has increased during the period that particular period. Thank you.
Thank you, Mr. Rohan, for all the information. There was a few problem with the mic, but I guess you can just recheck it again. Moving on, I would like to invite Mr. Titash's view in this same agenda. As we have heard Mr. Rohan saying that there's a lot of cyber crimes happening around, let it be the Zoom vulnerability or BMAP case or maybe the other PM funds case happening around. Mr. Titash, in your opinion, do you think that the cyber crime, what are the challenges which we can face when we are, witnessing these crimes around us? And would cybercrime will be less in case where there is absence of any virus? So, what is your opinion on that, Mr. Titash? Over to you.
Thank you, Ms. Nishi, for asking me about my take on this issue. So I would first like to address the aspect as to if the levels of cybercrime has been a high in case of this COVID-19 outbreak or had been prevalent prior to this. So it is to be understood and noticed that as we all are working out of homes or we are attending a lot of webinars or even colleges conducting a lot of online classes at this time, it is to be noticed that we are sitting right now at our homes using the basic services provided by our internet providers, which gives us the very limited and the very, if I can say, the basic amount of security protocols and the security protection on the internet that is required. So it becomes very easy for these hackers and other people to enter into our laptops or our devices and take away such data, because if, for example, we were in a college or if we were back to our workspaces, the amount of security protection given by the providers there is high because of various other aspects, such as having a firewall or having a very secured server or even having cloud. Now you all must be wondering that if my account has been breached or not, or if my data has gone somewhere else based on a hacking incident. So if I might ask my moderator, Ms. Varnika, to please start sharing the screen so I can conduct a small activity for my users. So this is basically a website where you can check if your email address or your passwords have been a part of any hacking incident which has happened prior to today's date. So we have used one of our fellow panelists, Mr. Rohan's email ID to check if it has been compromised. So we can see that this email ID has been compromised on one site which was breached. Furthermore, if we come down, we can see as to which site was a victim of such a breach. And here it shows that Canva in May 2019 had suffered from a data breach which affected close to 137 million accounts. And we also come to know as to what type of data has been compromised, such as your email address, your name, your password, your usernames. Furthermore, this site also provides as to how many websites, how many accounts have been breached, and it also talks about which have been the largest breaches till now and which has been the recently added breaches. If we see in the recently added breaches, we can observe that Zoomcar accounts have also been hacked recently. And Zoomcar is one such platform that we in India use quite a lot, and it raised a lot of questions as to now what do we do ahead when there's such a breach in the future. So for this, I would like to address two challenges that I feel, in my opinion, exist right now when we are approaching the courts to report such incidents that we have been victim of. Now we know that in India we have two very comprehensive set of laws which are governed by the Code of Civil Procedure, which deal with mostly cases which are out of civil nature, and the Code of Criminal Procedure, which deal of criminal instances. So when it comes to jurisdictional aspect, we have the CPC, CRPC, the IPC, as well as the Information Technology Act, which cover these issues. And I shall slowly be addressing each section under these specific acts. So under the Code of Civil Procedure, when it comes to civil suits, so if I can give you an example, so if right now, if I'm going to be booking maybe a t-shirt on a site, which is being run by a company in Singapore, but the site belongs to a company which is functioning out of maybe USA. So the question arises as to where can I have a suit filed in case if my payment doesn't get processed and if I want a refund. So for this, it is mostly a civil nature suit because we are asking for maybe a refund in the money and it has no criminal nature to it because of various other reasons. So for this, we have section 20 of the Code of Civil Procedure based on the concept of cause of action, which the Civil Procedure Code deals with under section 15 to section 20. So the cause of action can also arise when there have been transnational issues outside and the same has affected any user or any device within India. So we see as to how civil cases can be dealt under CPC under section 20. Now further, when I come to criminal activities such as identity theft or posting of obscene images or even hacking, phishing, so we have section 179 of the Criminal Procedure Code, which deals with any incident which happens outside the territorial jurisdiction of India. And if such an incident has a consequence on the Indian user or any device which is currently in India, then through section 179, the court can look into such a matter and adjudicate upon it. To substantiate more with section 179 of CRPC, we have section 3 and section 4 of the Indian Penal Code, which briefly describe as to what are the territorial and extraterritorial jurisdictions of the Indian criminal courts while conducting such cases. Lastly, when it comes to the Information Technology Act itself, which is the mother act regarding the cyberspace in India, we have section 75, which is quite similar to all the sections I mentioned prior, where it says that any instance where there has been a hacking or any other cyber related crime which has occurred outside the boundaries of the Indian territory, such cases can be taken into cognizance by the Indian court as long as the person affected or the device affected falls in the Indian territory. So with this, that's my first issue that I would like to address with respect to jurisdiction. Now, secondly, the issue that I would like to further address is with respect to admissibility of the electronic or digital form of records. Why am I bringing this up? You might be wondering. As my fellow panelist, Mr. Rohan had mentioned about the entire facade of the boys' locker room, which happened a few weeks back, and how, as a matter of fact, we have seen that the cybercrime department of the Delhi police had taken suo motu cognizance of such an issue by using the Instagram stories or maybe the Snapchat chats or even the Instagram post as a form of evidence to establish such a case. So now the whole concept of documentary evidence, electronic evidence, digital evidence falls under the scope primarily of the Indian Evidence Act, along with sections which are supplemented by the Information Technology Act, which deal primarily with what are the crimes which have been committed and how they are to be tried. I will be focusing more on the Indian Evidence Act because that deals with how we are going to provide such evidences before the court. So under section 3 of the Indian Evidence Act, which talks about what form of documents can be considered to be a documentary evidence, through judicial interpretation and the judicial activism, we have seen as to how this scope of documentary evidence has been expanded to even include digital evidence and electronic form of evidence such as maybe a screenshot or maybe a WhatsApp message or a mail ID or even a mail or even a video sample of a session which you're recording on your screen. So section 3 has slipped into the aspects of covering electronic evidence which can be admitted to the court. Now, when we are approaching the court to provide such evidence, so there are three main sections that I have realized are very crucial for us to know right now. We have sections 65A and 54, which deal with how and what type of evidences can be actually put forth the court, and these basically have expanded itself to even include documentary and then electronic and digital evidence also, provided when you're approaching the court to file such an evidence under section 65B, which lays down the criteria and the conditions which are to be fulfilled while admitting these form of evidences has to be followed. And out of this, one of the most important provision under section 65B is the production of a certificate to basically establish the genuine nature of the evidence you're being provided. So this certificate is usually given by a police inspector who has looked into such a case or to whom such a FIR or a report has been filed. So this basically proves the authenticity of such an evidence, because at times what people might do is they might probably use some form of editing software to show that there have been wrongful acts, and then they might go for a recourse. So this section 65B has been put in place to prevent such misuse of powers and to even ask the courts to look into the actual evidentiary value of the document being provided for a better adjudication. So with this, I would feel that I have addressed the basic concepts with respect to jurisdiction and admissibility, because in my opinion, these are the two main important that we are to be made aware of right now in case if we are going to be a victim of the next cyber breach or cyber attack. Thank you.
Nishi,
Thank you,
please
Mr.
unmute yourself. Thank you.
Yeah. Okay. So thank you, Mr. Tatash, for all the views of the cybercrime and its current impact in the society. So with this, we come to the end of Agenda 2 of today's session. Now we will be going ahead and taking some time for questions now. It looks like we have a few questions. As a reminder, if you have any question that you have not submitted, you can drop it in the Q&A chat box. So the first question is from Arushi, and her question is intermediary bound to screen the content on their platform or not? I would request the panelists to come forward for the answer.
Ms. Nishi, I would like to answer this question. Uh, Intermediaries, as per the IT rules of 2011, they are not bound to screen all the content on their platform, but they have to disable the content when they receive the actual knowledge. And this was also held in the case of MySpace versus Supercassette by the Honorable Court.
Okay, thank you, Mr. Rohan, for the answer. The second question is from Karan Agarwal. His question is to Miss Anushka about what is the concept of auto block of the unlawful content available on the website of the intermediary? I would request our panelist, Miss Anushka, to come forward for the answer.
Thank you for this question. As I recall, the doctrine of auto block was first introduced in the case of Sabu Matthew versus Union of India by Supreme Court, in which they direct the Yahoo India and Google India to make an in-house expert body which would see that no person can go for the information which is prohibited under our Prenatal and Pre-Diagnostic Test Act. So the nodal agency would provide the information to the search engines, and search engines would then block the websites which are promoting such information which are prohibited. Thank you.
Okay. Thank you, Ms. Anusha. The next question is anonymous. It is it necessary to file a certificate before approaching the court? I would request Mr. Rohan or Mr. Titash to come forward for the answer.
Ms. Nishi, if I might answer this question. So as we have seen, like as I've even explained about Section 56B of the Indian Evidence Act, so it is to be observed that Section 65B of the Indian Evidence Act is more of a procedure given to the courts and to the person approaching the court when they're providing such an evidence. So the courts have realized that not everyone can be well equipped to understand this basic norm, or not everyone can be well equipped to even gather such a data to provide as an evidence. So what usually has happened right now through judicial intervention also, and I think there's a case which has quite well dealt with this aspect of Section 65B being a mere procedure or a mere procedure section. So it's a case of Shafi Muhammad versus State of Himachal Pradesh, where the courts have the Supreme Court has held that even though Section 65B talks about production of a certificate to establish the authenticity of your evidence, but the courts at times can even relax such a provision based on the concept of justice and equity. And if the courts feel that such evidence can be admitted without the provision of a certificate, then the courts have the power to do so. So I think I can, in a way, justify the question asked about the production of certificates, where I will repeat once again, that is not a complete mandate, but it is just a mere procedure which is established by the law for production of such an evidence.
Thank you, Mr. Tatash, for the answer. Now I would request my co-moderator, Ms. Harshvi, to further proceed with the agendas. Thank you.
Thank you, Ms. Nishi. Now I will be beginning with the agenda 3. That is, whether IT Act and landmark judgments are sufficient enough to tackle such issues. No one in this entire world can deny that the cyber law has positive roles, but In the same way, I would say that it has drawbacks as well, because because if the cyber law gives us advantages of giving a legal recognition to the electronic records as well, it has cyber drawbacks as well. It does not give the rights to the it does not give any rights for intellectual property rights. So, Ms. Anushka, would you like to give your insights only if IT Act is sufficient enough to cover all the ambit of cybercrimes?
No, in my opinion, Ms. Harshvi, the provisions of IT Act are not exhaustive, as these provisions clearly retaliate the intent of the legislature. Technology is being mixed up in our daily lifestyle, being unbrindled by humans if it is not misused. So, to fill up this lacuna created after many years, a proper meanus operandi, that is, our IT Act, is created to deal with the issues which are related to technological offenses, but not in toto, but as a complementary to another enactments. There is a clear distinction made between the acts where the computer is the object of the crime, speaking of where there is theft of hardware or software. Secondly, where the computer is the subject of the crime, for use for the purpose of breaching of confidentiality or integrity or even data in processes. And thirdly, where the computer is the instrument of the crime, merely encompassing the fraud or pornographic offenses. Now, as we all know that the cyber-related area is so vast and it is so evolving, in the sense that new and new crime are being shown up again and again, and the new way of doing that crime is being shown by our tricksters. Coming to our Information Technology Act, it is a special act. And the object behind this act was to legalize all the transactions which are related to electronic data interchange, e-communication, and e-commerce. So it is apparent from the object of the act that the intention of the legislature was not to clearly, completely, and exhaustively exclude the offenses which are related to crimes, to cyber crimes and information technology from the purview of our Indian Penal Code and other conventional laws. Whenever the legislature intend to do so, it generally exclude that provision from our general laws, as evident from our section 81 of the IT Act. Now, section 81 of the IT Act does not clearly connotes the exclusion of all the provisions from the general laws. What it does is that it merely validates the provisions of our IT Act even if they are inconsistent with the provisions of other conventionals and other general laws. Therefore, seeing the example of identity theft, there is no provision in our IPC or in our IT Act where there is a clear prohibition of the applicability or culpability under either of the enactments. Hence, in my opinion, the amplitude of the IT Act is not exhaustive in totality. I would also like to quote a judgment here of Gaya Prasad alias Mukesh versus State. Now, in this case, the court held that the principle of generalis speciali non-derogant would not be applicable to penal laws. Therefore, there can be an act that could be tried under IPC and our IT Act as well. So, whenever this situation arises, the FIR must be registered of both the offences. If prima facie case is made out of both the offences, the charge sheet shall also be filed of both the offences. Now, it is on the court which is trying the offence to empower the cognizance of the offence under either of the enactments. That's all. Thank you.
Thank you, Ms. Anushka. So, Titash, based on the points given by Ms. Anushka, can you throw some light on our viewers about various legal
Surely, Ms. Harshvi. So, as Ms. Anushka has mentioned as to how the IT Act is quite unable right now to cover all aspects of law and crimes which are arising right now, because we have seen, for instance, that the way that the cyber crimes and the cyber world is growing right now is very rapid. And it's very difficult for such an act to preempt or to understand that if such a crime is going to occur now or not. Because if I can give a very simple example, so if we have seen as to how maybe this platform of Zoom itself didn't exist quite a few months back, and as soon as technology advanced where the providers are giving out such services, a lot of legal concerns are also raised. So I will primarily be dealing with all forms of legislations that are right now prevalent in India and which are very prevalent to this agenda specifically. And further on, I will be giving the examples of such cyber crimes with the legal sections under the Information Technology Act, because it's a special act, and as well as the Indian Penal Code, by explaining as to how, if there are any shortfalls or if there are any loopholes, you can approach the court by using provisions of both the acts, and the courts are to decide upon which section or which act they're going to focus more upon for better adjudication. So now when I'm coming to the various laws, rules and regulations right now, which are in India, along with the landmark judgments. So as we all are aware that the cyberspace in India is currently regulated by the Information Technology Act, which came out in the year 2000. As well, there have been constant amendments. And the most crucial amendment, in my opinion, is the amendment of 2008, where a lot of cyber crimes were realized by the department and the ministry, and hence they have provided penalties for such. So we have seen as to how in a matter of 8 years itself, as soon as the act came out, the government had realized that a lot of potential threats might come up, because in a matter of 8 years, a lot of changes were seen on the cyber world. Then if we come to the various rules and regulations which are following the IT Act, so I will be talking about three main rules, which is the 2009 rule of decryption, monitoring and interception, which the government has the power to look into such accounts or such platforms where they feel that the content or the usage of such platform is going to cause a potential threat to maybe an individual's life or even a threat to the national security. So they can actually look, if they find anything suspicious, they can even look into our accounts right now to see and to prevent a widespread of such a crime, which is to be anticipated. Then even in 2009, there was a regulation which came out with respect to blocking of websites. So why did this come out? Again, related to the previous rule, which I mentioned about monitoring, decryption, and interception, because of the fact that governments have tried to prevent such people or hackers to wrongfully deceive or to wrongfully use such platforms to commit their offenses and to make us fall under a hardship. Then, in my opinion, the most special and the most important rule personally I would feel is the 2011 rule, which deal with the management and storage of sensitive personal data. Why am I talking about this regulation is for the mere fact that a lot of privacy related concerns have come up before the Indian judiciary as well as the Indian government, because we have seen in the past 3 4 years as to how the Supreme Court adjudicated upon the aspects of privacy through the Puttaswamy 1 judgment, which is known as the privacy judgment, as well as the Puttaswamy 2 judgment, which is commonly even known as the Aadhaar judgment, and how these two judgments, along with the Aadhaar Act, which came out as soon as the Aadhaar program was launched, along with the 2011 rules regarding sensitive personal data, had led a pathway for the development of the Personal Data Protection Bill, which is right now in our parliament waiting to be enacted in full force, because the government have realized that privacy right now is a huge issue which everyone is going to face, because of the fact that even concept like AI, machine learning is coming up, which is going to give people a lot of tools to enter into such secure databases also and look into it. So for example, if I can talk about such database regarding sensitive personal data, we have seen as to how a few weeks back with respect to the Arogya Setu app, a French ethical hacker had told the government and even the Ministry of Information Technology that this Arogya Setu app can be hacked quite easily, and a lot of information is potential and it is going to be breached very soon if someone else has an access. And we have seen as to how this situation was not anticipated as well by the government, but the government has also looked into and has improved the norms and security of such an app. So now when I'm coming to the legal sections with respect to the various cyber crimes that are occurring right now, so what I will be doing is I will be talking about every instance of a cyber crime along with a supplementary legal provision. So now, as my previous point was about sensitive personal data and how people can be penalized or bodies can be penalized, we have section 43A of the Information Technology Act, which deals about how governments or bodies dealing with sensitive personal data are to ensure proper safeguards and maintenance of such platforms and such databases. And if there is a breach, there can be a heavy fine which can be imposed upon such bodies. So we can see as to how section 43A also can provide a form of remedy even if a government body or government related body is not following the norms as laid down by the Act. Then we have section 43, which deals with hacking, which can be quite well linked with section 43A because people usually enter such databases to gather only sensitive information. And then we have section 66, which talks about data theft. So I think all these three sections of the Information Technology Act deal with a very similar situation. Now, in case, as my fellow panelist, Ms. Anushka, had mentioned that at times even the Indian Penal Code provisions can also be invoked in case if there are certain shortfalls. So with respect to the aspect of sensitive personal data and data theft, the courts have realized that under section 424, which talks about fraudulently or dishonestly removing any property, aspects of digital property can also fall under such a provision. Now, if we have seen the news and followed the news, whereas as soon as our Honorable Prime Minister had launched his PM Cares Relief Fund, a lot of people have actually created fake UPI IDs. And I hope not, but someone might have fallen into the trap of giving a huge amount of money to such a fake ID. Now, how do we address and how can someone actually go ahead to the court to establish that they have been a victim? For this, we have section 66D and section 419 of the Indian Penal Code, section 66D of the Information Technology Act, which primarily deals with cheating by personation. So as my fellow panelist, Mr. Rohan, had also given an example of phishing, and I'm sure quite a few of you must have seen this show on Netflix called Jamtara, so to get a very basic idea of how phishing works. And if not, I will just explain phishing as to what happens. Basically, someone probably impersonates themselves to be a bank employee and asks for maybe your card number, your CVV number, or any other bank related account to enter and take away all the money that you have in your account. So this aspect of phishing and the aspect of even having a fake UPI ID is dealt under both section 66D of the Information Technology Act as well as section 419 of the Indian Penal Code. Now, what would happen if your identity or if your email address has been a victim of a data theft? We also have this concept that the Information Technology Act has tried to cover, which is known as the aspect of identity theft. So, what if maybe someone under my name might approach maybe the bank to say that, okay, fine, I need to withdraw my amount. And the bank also falls for such a situation, and I come to know that amount has been deducted from me. So I can approach the court under section 66D because at times we see if we get a SMS, we usually get SMSs when we enter into such online transactions where they say that such an amount has been deducted. If not done by you, then please call or SMS such and such number. So section 66C would fall even in that situation. Now, if you would have recalled in our first agenda, my fellow panelist, Miss Michelle, had also mentioned about the aspects of privacy. So, privacy, as it's becoming a huge concern, we have section 66E, which talks about the provision which deals with if any person breaches any other's privacy by posting such some information online or even getting into their database. Section 66E provides a very strong penalty in the form of a fine as well as an imprisonment. Now, the last issue that I would like to address with respect to cybercrime is the posting of obscene materials on these social media platforms or any other platform. For this, we have quite a few sections actually falling under the Information Technology Act as well as the Indian Penal Code. A few to name is section 67, 67A and 67B, which prohibits any person to publish such an information, be it in a digital form as a picture or even maybe a blog or even a video on a social media platform or any online platform as such, or even transmitting such a information or such a data. They can fall under the scope of section 67A, B, and the section 67 itself. And then if we go to see with respect to the provision of the Indian Penal Code, we have section 292 and 294 along with section 502, which basically deals with the violation of the rights of a lady, that is basically dealing with the violation of outraging the modesty of a woman. So we have seen as to how the aspect of obscenity has quite well been dealt by the Indian legislations. Now, lastly, now if we have all understood as to how the entire Zoom bombing issue had come up and how it went all the way to Supreme Court, so one crucial part that I feel right now, before I conclude, is the section 684A of the Information Technology Act, which provides end-to-end encryption. So what does this basically do is it ensures that whatever conversation you're having is protected from anyone else from having an access to it. Now, if I can request all of you to probably just go to this, a small green shield is there on your screen with a tick mark. And if you go and hover over that, you can see as to how it talks about how the encryption has been enhanced. Why has this provision come in is because the fact that Zoom as a platform had gone all the way to the Supreme Court and the central government, and these two bodies have given guidelines by saying, by telling Zoom that they have failed to abide by all these provisions which deal with encryption. So I think that based on today's scenario that we are facing right now with respect to the instances of cyber crimes, I think I have been very able to touch upon all the important sections and helping you understand as to how all of these sections work hand in hand.
Thank you, Tatash. That was a really enlightening session of briefing wherein you touched upon all the laws, the sections, the subsections, and everything. And thank you so much for clarifying the doubt regarding the Zoom, because our Q&A box is flooded with questions regarding the Zoom thing. So thank you so much for clarifying that. And also at this juncture, I would like to take this opportunity to thank our panelists and viewers for sticking with us for this long. And we need to appreciate a couple of them. For first, we have Kandrani Bhattacharya, who writes, "Thanks to all the panelists for the insights provided to a lame person like us. Cheers to all the hard work, all you have put, all the very best." So that's a good compliment for all the panelists. Thank you so much, Kandrani. Please stick with us till the end of the session. All right. We have another one coming in by Mannat Sinha, when she says this has been one of the most informative sessions. Thank you, Mannat. At the same time, there is a very peculiar question which has come up in the Q&A box. That is phishing the same as salami slicing, also known as the salami attack? So either Titash or Rohan, anybody of you would like to answer this? Or any other panelists who will be willing to answer this, whether phishing the same as salami slicing or the salami attack?
Nitish, I would like to answer this.
Yes, Rohan, please go on.
Salami attack is different than the phishing attack. In phishing attack, we try to hide our identity and show to the victim that we are from such and such organization. Whereas in the salami attack, it is not like that. Thank you.
Okay, all right. So another question that I think it's pretty basic but needs consideration is there any difference between cyber law and cyberspace? This is an open question to the entire panel. Any one of you can answer this, whether cyberspace and cyber law are two different things or not.
I would like to answer this again.
Okay, Rohan, please go on.
Cyberspace is the environment which we can't see, but we are the users of it. And to govern such space, we have cyber law for this, which is enacted by our parliament also.
All right. All right, the rest of the Q&As will be taken in a short while as we conclude with the session 4 of this evening. So Harshvi, over to you. You can continue with the agenda 4. Thank you.
Thank you, Mr. Roy. So, Titash, when it comes to the aspect of privacy and cyber crimes, can you tell us more about it?
Surely, Ms. Harshvi. So, as a matter of fact, we have seen as to how privacy has gone up always before our courts as a main concern when it comes to like issuing or fighting for maybe cyber rights, if I can say, or even by addressing cyber crimes. So, as I have been following the various judicial pronouncements, and matter of fact, a few weeks back in the state of Kerala, a case had been filed before the High Court with respect to if how the state government of Kerala is right in providing information regarding the COVID outbreak to a external body in the United States of America. So what basically happened is, because as we know that the government is trying to track such outbreak by taking all these details and maintaining a database. So state government of Kerala, we have seen as to how they even have their own set of laws which are very similar to the Disaster Management Act, which is right now prevalent all over India, and how they have special provisions to enhance the security and even enhance the safety. So what basically happened is the state government of Kerala got into a contract with this US-based company called Sprinkler, where they sought the assistance of this company to probably understand, read, track, and even maybe decipher and to tackle such an issue of COVID outbreak, by giving the information regarding the active and suspected cases to the company. Now, this case was actually filed by a lawyer before the Honorable High Court of Kerala by stating that this is a direct breach of a privacy after the Puttaswamy judgment, which states that all the sensitive personal data, which do include health related data, are not to be given out to any other individual or any other body. So this was the main issue which came up, and the state government of Kerala had actually told the honorable court. So as of now, if I can tell my user, there's no fixed order which has been passed. It's rather a interim order which has given certain guidelines. So you can also go up and look into this case. So if I can state the case name, if you can write it down, it is Balu Gopalakrishnan versus State of Kerala and others. Okay. So now what the state government of Kerala had mentioned in this case was, because right now the Indian softwares or the Indian databases are not that well equipped to deal with a huge volume of cases, because the amount of cases which have gone through the state of Kerala were close to 8 million accounts whose details had been given to this body. So now what the state government of Kerala told us, they are right in doing this, and they have taken all the necessary precautions in doing such an act by giving such an information outside the territorial jurisdiction of India. And a matter of fact, even the Union of India, who has the respondent in this case, has actually gone ahead and told that the state government of Kerala should have approached the central government or the Department of Information Technology, so that the department can also enhance such a mechanism. So we are right now awaiting for the final judgment, because the Union of India is yet to give its side of arguments and the court is yet to adjudicate properly. But if you all have the time, if you're interested to know as to how this case is proceeding, you can always look it up on the various portals, the various blogs which have dealt with such a case.
Thank you, Mr. Tatash. So, Ms. Anushka, would you like to add something to it?
I would like to say that with the passage of time, the reliance of electronic records during investigations has increased drastically. So the laws need to be laid down in most certain manner. When the offense comes under two separate definitions of two separate enactments and it is similar, then the Section 26 of the General Clauses Act, Section 71 of our Indian Penal Code, along with Section 31 of CRPC would come into play. That's all. Thank you.
Thank you, Ms. Anushka. Now, I would ask my co-moderator, Ms. Nishi Jain, to begin with the next agenda.
Thank you, Ms. Harshvi. Moving on to the final and the most important agenda of today's webinar, which is how to keep yourself safe in cyberspace during and after COVID-19. So after having a look at all the cybercrimes which is prevailing in the society, its legislations, which already our panelists have discussed in the above session, it's very important that every person knows how to keep himself safe in cyberspace by enhancing his cyberspace security. It is a very famous quote which says, "Prevention is better than cure." Digital transformation has enabled organizations to evolve security safeguards to prevent intrusion, but still personal sensitive information and financial information of a person is always at a risk due to the increased cyber attack, which is very difficult to also tackle. So I would like to invite Ms. Modi's opinion on this. What's your insight on this, Ms. Modi? Over to you, Ms. Modi.
Ms. Nishi, according to me, in an era of cyber everywhere, with more technological transformation, use of cloud and broader networking capabilities, the threat landscape continues to increase and cyber criminals will look to attack operational systems. Organizations can improve their defense posture and attack readiness with good cyber hygiene and incident response strategy, architecture and implementation of cyber recovery solutions to mitigate the impact of cyber attacks. Two-factor authentication is another way of adding security to your system. A hacker may happen to steal your password but can't see the verification code or OTP on your smartphone. This type of security will also alert you when there is an unauthorized entry. And apart from companies' information, personal sensitive information and financial information of an individual is also at risk, as during the period of this lockdown, people are accessing social media websites such as Instagram, Facebook, Twitter, etc. more frequently, in addition to watching movies and series by subscribing to web channels like Netflix, Amazon, Hotstar, ZEE5, etc. and also indulging in online games by installing various applications. All these activities are supported by the internet. People tend to provide and or give permission to access their personal information, which is readily available on their phones, laptops, and or social media accounts in order to use the services provided by the applications. Many a times, in order to purchase apps or access online services, financial information too is shared by the users. Another primary issue that has emerged is fake news or rumors that are spreading rapidly across the country. It was observed that various rumors with respect to COVID-19 virus too were also false and were meant to create tension or fear amongst the people. There was a fake news circulated which enumerated a treatment to the COVID-19. Such news is not only unethical but could also lead to severe consequences. The Indian government, social media channels, and the police together are taking measures to control the spread of rumors. The Government of India has launched a chatbot on WhatsApp to address user queries, FAQs, and pull down rumors on the coronavirus pandemic. Similarly, Facebook has also launched a similar chatbot for India that will help verify fake news and curb the spread of rumors. The IT Act 2000 is regulating cyber crimes in India. Indian Ministry of Communication and Technology's e-governance department is also working towards promoting new apps related to the control of the COVID-19. However, it is also essential to be cautious and responsible while sharing the data, handling companies' information, and before sharing any message on social media platforms. Thank you.
Thank you, Ms. Modi, for your information. It is very important for a person to keep himself safe in cyberspace by adopting a lot of measures which are available. So I would like to invite Mr. Rohan's opinion on the same. Mr. Rohan, how do you think an individual can keep his data privacy safe in cyberspace? What are the measures which are available to him?
Thank you, Ms. Nishi, for
Over to you.
asking my opinion on this. I would like to suggest the viewers that whenever you browse any website, you have to be very clear that the URL of that website is HTTPS or HTTP. If it includes only HTTP without S, then you must not browse that. And I shall also request the moderator, Ms. Swarnika Tyagi, to please share the screen so that I can share something. Here you can see that this is the official website of Kali. It is an operating system which was developed for the ethical purposes only. But as you can see, you can download any version of this, whether it be 64-bit or 32-bit, and people are using this for unethical purposes also. Please move on to Metasploit. It is also developed for ethical purposes, but unfortunately people are using for unethical purposes. You can see the download button here also. In a single click you can download by visiting this URL. Please move on to Nmap. Here is a list of updates in this particular software. Again, you can download this, and you can have the tutorials if you are a beginner in this. Such kind of softwares are available for free and are easily accessible. And please move on to Wireshark also. Wireshark is a software that captures the packets, whether it be a LAN or a Wi-Fi. It captures the packet and it can hijack your sessions also. The hacker can even see what you are watching on your phone, whether you are browsing or chatting with someone. He can have total access by using this software. Tutorials of this are also available. And please move on to PrivNote. PrivNote is a website that provides you a feature that you can here you can type a message and send to your victim. The moment he read your message, it will get destroyed after that, and he cannot view that message again or show it to somebody else. And even you can use the option of email to notify when notice is destroyed. Such kind of things are freely available for every user. So these all things should be made only available to those who are using it for ethical purpose or are holding a degree or a certificate in that particular field. Please move on to cybercrime portal. The only way to decrease the crime in this period and in the coming future also, I believe, is to just report the cyber crimes. This is the portal created by Government of India, and I assure you, this is the portal which is not like any other portal. It responds you within very few hours. Please, here you can see that there is a section particularly for women and child related crimes. Here you can also report anonymously if you want to hide your identity, and you can have a you can also track and see your report. And please move on to report other crimes. Please click on file a complaint. Please click on I accept. Here you can see you can report any other types of crimes other than the child and a woman, and you have to enter all the details. And please, you can also enter the if you have doubt on anyone, you can also enter the suspect details also in this portal when you proceed further in this step. And this is all. I suggest all of you, if any you feel you are a victim of any cyber crime, you must report to this portal. They will take action very soon. This is all, Ms. Nishi. I want to add only this thing. Thank you.
Thank you, Mr. Rohan. Now, we will be taking up few questions from the attendees. So, our first question is from Ms. Vaishnavi Parikh. How can we differentiate between vulnerability, risk, and threat?
Ms. Ashwi, I would like to answer this question. That threat is something where someone with the potential causes harm by damaging or destroying the official data to a system or organization, like phishing attack. And vulnerability refers to weaknesses in a system that makes threat outcomes more possible and even more dangerous, like cross-site scripting. And risk refers to a combination of threat probability and impact or loss. Like in simple terms, it is related to potential damage or loss when threat exploits the vulnerability. Thank you.
Thank you, Ms. Modi. So our next question is from attendee Karan Agarwal. Which police station shall have the jurisdiction to investigate a case related to cybercrime?
I would like to answer this question, Ms. Harshvi. As I remember, as per Article 246 of our Constitution of India, public and police order is in the responsibility of the state. Now, due to the transactional and borderless nature of our cyber crimes, we cannot adhere to a particular jurisdiction of a police station. Hence, the government of India has made an online portal, as we have already shown, where the complaints can be filed to facilitate the public. Thank you.
Thank you, Ms. Anushka. So our next question is from attendee Jagriti. Do you think that state governments are right in taking such steps in mentioned in the Balu case?
Thank you, Ms. Harshi, for asking me that question. And so, if I can talk about the validity of the State Governments Act, now if we see the Personal Data Protection Bill, which talks about this whole aspect of who is a data principal and who is a data fiduciary. And now, see, if I can put out my points on whatever I have understood from this cases. Firstly, that the state government in this case was not justified in approaching such a body outside India based on, I think, Article 229 of the Indian Constitution, which talks about government contracts. So here, state governments can't directly give out such information because they act as a data fiduciary because of the mere fact that they're storing such sensitive personal data. Now, in case if the governments had to provide such a data outside the scope of their maybe repository, then even the PDP and even the Kerala High Court in this case has provided that active consent is required from the data principal, who is basically the person whose data is being used. So I really don't think so that the state governments can actually provide such information without getting consent and approval from the central government, as well as the Department of Information Technology, and as well as the data principal, who is the individual whose details are going to be shared. So this is what I think, in my opinion, is to with respect to this case.
Thank you, Mr. Ditash, for the answer. So with this, I think we come to the end of this webinar. It's been a pleasure being with you all today. If you have any additional questions or your questions are being unanswered, we would be happy to hear it from you and answer it. You can reach us through the email, which will be sent after the end of this session to you. So on behalf of my team, I would like to thank Ms. Varnika for her technical support throughout this webinar. And I would also extend my thanks to Ms. Aparna, Mr. Dhruv, Mr. Anubhav, and Ms. Smriti for all the background work. I would like to thank the entire panelists for their inputs in today's session. Their session, I am very sure the viewers found it very interesting and very insightful. All this would not be possible without a true mentor, Manish sir, Saugat sir, and Rubban sir, who has guided and motivated us from the idea of doing a webinar to motivating us to become a better version of ourselves. So my entire team specifically thanks you all, thank you sir for all the motivation and the idea of doing a webinar which came up. My team and
Let me jump in between. I'm so sorry. Guys, you did a fabulous job. Thank you so very much to all the panelists for enlightening all of us. I mean, throughout the session, I was just gazing at all the audience, taking all the notes, taking all the sections which I myself have not dealt with as of yet as a law student. And that really cleared out the roadmap as to what all I can and possibly come across while studying cyber law as a subject. And on behalf of JLJ Law Offices, it's just a small disclaimer for the sake of it, that all the information that has been shared is a part of our JLJ Interns program, and none of it constitutes as a legal advice in any manner whatsoever. So this is all the hard work of our law students, and this definitely shows that how committed we as a team are towards JLJ and the internship projects that we have undertaken under the leadership of Manish sir, Saugat sir, and Rubban sir, and the entire JLJ office. Thank you.
Thank you and have a great evening ahead. By this, we'll end the webinar. Thank you so much for attending.
Thank you so much, people. Have a great evening ahead. Thank you.